Can you
Uh,
update me on that, please?
of course. This matter was adjourned from November 14th to monitor Ms. Lonsberry Burns' payments and her income withholding order. She was to pay directly until the income withholding order became active. Uh, Her monthly obligation is $256 with an additional $128 ordered on arrears. Balance is currently sitting at $7,861.20. We did receive 4414 in December, but nothing for January. It does appear she had secured employment, but now is no longer employed.
Is Ms. Lounsbury Burns here today?
Right here.
All right, I do see you now. Thank you. Mr. Brown, how would you like to respond for your client?
Your Honor, I did speak with Ms. Lounsbury Burns. She did tell me that she had turned in applications. However, she did end up, as was just mentioned, getting a job. It appears that she got very ill, ended up going to a hospital. I don't have that documentation yet, but she did get fired from her job because she was in the hospital for a couple of weeks. She is currently trying to regain employment.
Ms. Burns, do you have some documentation that indicates that you were in the hospital and for how long?
I can get it and send it to the front of the court.
It wasn't for a couple of
And it wasn't a couple of weeks. It was only for like 4 days.
No, I apologize. I heard that wrong.
All right. So if you're only in the hospital for 4 days, how'd you get fired?
They just let me go because I only worked there for 2 days and I got an infection from working there. And then I went to go get my job back and they said they talked to the GM and then never got back to me. I called again and never got back to me.
So
So I am
what dates were you in the hospital?
I can probably pull that up for you, actually.
Hold on, we're pulling it up.
We got a good on the my chart on.
It was like, I don't know that he's looking it up right now. It's like in December.
Well, we talking the beginning of December, the end of December?
Again, we're just getting on her my chart.
We're looking it up because I don't remember.
My health info. Okay.
And I can email the documents to the front of the court too.
Would it be 11? 11/21?
I'd say in the beginning of December, before Christmas.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. Today's case centers around unpaid child support, mounting arrears, and a defendant who claims illness cost her employment. We're talking about a monthly obligation of $256 plus $128 toward arrears, with a balance sitting at over $7,800. The judge isn't just looking for excuses, he's looking for accountability. The real question is this hardship or is this neglect of legal responsibility? Let's see how this unfolds.
So what stopped you from getting a job for the rest of December and now almost all of January?
I've been looking. I do have an interview on Monday at Iron Pig. I'm still actively putting applications in.
How many applications have you put in?
I put it on Indeed and I have a resume, so maybe like 5 or 7. But like I said, I have an interview on Monday for Iron Pig.
Ms. Lounsbury Burns, 5 to 7 applications in approximately a month and a half is woefully inadequate.
Yeah, I've just been really sick, like in and out of the ER as well. But I can do better. Hopefully I get this job on Monday.
When was the last time you had contact with the friend of the court?
When I got my job at Big Boys, I turned in 10 applications to her, and then I ended up getting hired. And I called and let her know.
Which was when?
December.
Why did you not have contact with the friend of the court after that until today?
Because I've been actively trying to find a job. And I was going to call
Just-
when I got the job.
You just told me that you've only put in 5 to 7 applications in that almost month and a half period of time. That's not trying to find a job.
Well, I have a resume out there too for Indeed. But I'm pretty
That
sure I'm going to
just
get hired
sits-
on Monday.
That just sits there. That's not you doing anything.
Here's where things shift. The judge is no longer focused on hospital visits or job interviews. He's zeroing in on legal obligation. In child support cases, courts don't operate on good intentions. They operate on enforceable orders. 5 to 7 job applications in 6 weeks? That's not considered a diligent job search by most judicial standards, and simply posting a resume online does not satisfy a court's expectation of active employment pursuit. This moment is critical. The judge is establishing something very clear. Child support is not optional. It's not flexible based on mood, illness, or convenience. It's a binding financial duty. Let me ask you, do you think the judge is being too harsh here, or is this exactly the accountability the system requires?
I don't know if you really understand what your obligation is. Your obligation is to pay 256 plus 128 every month without excuse, without saying, well, I'm doing this or I'm doing that. There is no, I don't have to do that this month because I'm not feeling well. Whether you're feeling well or not, it's a requirement that you pay it. You don't have the luxury of sitting around and doing nothing.
I agree.
Well, I'm glad that you agree because that's what the law says. It's not just me preaching to you. That's what the law says. If the shoe was on the other foot, you would be asking me to tell the other person to make the payments to you, wouldn't you?
Yes.
And you would be angry about not getting those payments, wouldn't you?
Yes.
So why would you think that you can do what you did here?
I mean, I'm trying to look for a job. I mean, I was in detox. I have no excuse. I'm going to do better. I'm not going to sit here and do that.
I'm glad to hear that. So let's begin to act a bit more like an adult and do what we're supposed to do when we're supposed to do it. So I'm going to give you one more chance. Next month, you make your payment, period. End of story. Don't want to know why you didn't. Don't care why you didn't. Make your payment. And if you don't make your payment, I'm going to throw you in jail because that's apparently the only thing that I can do that's going to get your attention. I'm going to take you at your word that you know now what you need to do. So let's do that. We're going to adjourn this for 30 days, approximately. You'll get a notice of when to show back up again. Make your payment.
Okay.
And make the entire payment. Don't make just a partial payment. Give me the whole thing that you're required to do.
Okay.
You understand what you need to do?
Yes.
All right. Ms. Spillane, is there anything else for today?
No, sir.
That's all then.
What we just witnessed was a textbook judicial warning. The court confirmed the obligation, $256 monthly plus $128 toward arrears. No exceptions. The judge made it crystal clear. Next month's payment must be made in full or incarceration becomes a real possibility. That's not emotion, that's enforcement. This case highlights an important reality in family court. Effort alone isn't enough. Courts require documented action, consistent communication with the friend of the court, and above all, compliance with payment orders. One more chance was granted today, but next time, consequences could escalate quickly. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments. Was the judge fair or too strict? And don't forget to subscribe for more jaw-dropping courtroom breakdowns.
I'll see you next month.
Sorry.
Next matter is Cassandra Barber and Chris Stokes, file 19-18004-DS.